Adjournment request from item number 1 to 7. From item number 8 to 20.
Before that, we seriously encourage all the lawyers to, we would have no difficulty in hearing you physically. But if you can, as far as possible, at least for 2 days, you can use this mode as far as possible.
But as far as today's issue is concerned, my lord, we applied for the link, but the link came at around 10:20. So it was too
Okay,
late.
that
By the time
will-
you already started.
Oh, I'm not saying that
Right.
physical is not welcome.
Right.
It's very welcome.
Right.
But then we have done it for your convenience
Yes.
as an austerity measure, but we will be coming here. So if you're physically present, good enough. We have made it flexible so that nobody is faced with any difficulty.
Yeah.
We are only encouraging you to go for visual. This is an encouragement. We are not asking you to go. In fact, this is more comfortable, no? But
Yes.
let's see. For 2 days,
Physically, it's a very
for
comfortable.
2 days a week.
But
Yes. Yes, Mr.
In fact, I have come because in a bail matter, I have to place a charge sheet, which is consisting in 4 trunks. That's why I have to come.
That can't be done.
That can't be done online though. Otherwise, all my team is from the chambers they are saying.
No. This is because I have come. The entire full court has come out with a notice. Therefore, I thought we must let you know.
Lord.
When you come, you are most welcome.
Lord.
But that also is comfortable.
Lord.
Yes.
Lordship, I'd like to mention item number 8.
Yes.
Lordship has fixed an identical matter on June 5th.
We have fixed identical matter when?
On June 5th. If this matter may
this
be
mat-
tagged along.
Let get the number of that.
Yes.
Let this matter come up along with so and so on 5th of June.
Much obliged.
Yes.
May it please your lordships. Lordships, we had circulated an adjournment request with regards to item number 17, your lordship.
1-7.
17.
All. Adjournment slip has circulated. Give the date. Yes.
3rd August.
Lordship, if I may, sometime in June,
June is not possible. July, if you want, we can.
July,
July.
22nd July.
much old.
Yes.
From item number 22 to 31.
Lordship, kindly grant adjournment for 2 weeks for item number 81 of 2026. Bhupendra Goswami versus Assam Corporate Tax Bank.
Tell us the serial number. It's easier for us. 18.
24.
24. 24. What do you want?
Kindly grant adjournment for 2 weeks, and the opposition have no objection.
I have no objection.
All right, I'll wait for you. On behalf of the appellant and agreed to by the counsel for the respondent bank. Let this matter come up for consideration after 3 weeks.
28th July.
May I please the lordship, my lord, in item number 31, my lord, I have received a copy of the affidavit filed by the respondents today in the morning, my lord. So some time may be granted to file my reply, my lord.
My lord, I have signed, my lord. I have served the copy, my lord. We will find it.
He says that he has received it in the morning. He might like to rejoin.
It's being filed.
Yeah, at the instance of the opponent with
DP board.
Mr. D.P. Boda, learned advocate for the petitioner, seeks some time to file rejoinder to the affidavit filed on behalf of the state. For the aforesaid purpose, let this matter come up for consideration on after 2 weeks.
Yes, my lord.
19th June.
Obliged, my lord.
Obliged.
From item number 32 to 36, adjournment request.
No, please also. Item number 32 will file an affidavit in reply. That may be called for also.
At number 32.
32.
Lordships, may I please request, the pleadings for item 33 are completed. So may I please beg to fix any other day for hearing?
23.
33. 33.
33.
Yes, your lordship.
You're appearing for?
Mr. J.M. Chaudhary.
For appellant.
As prayed for. Have you informed the other side?
Yes, Your Lordship.
As prayed for on behalf of the appellant, re-notified. 3 weeks.
10th of August.
Deeply obliged.
Any other request?
This was property society, that's not a problem. Property.
Daily list for orders, item 1.
Service report, inspect of museum, respondent number.
My lord, here is the order, office note date 21/5/26, my lord. The respondents, though, ID card has not been returned, but they have entered appearance, my lord.
I'm appearing for respondent number, for respondent number 2, Union Bank.
And who appears for 3?
Already represented already.
Already represented. 3 is already represented.
No. I'm only for a performance number 2.
1 and 5, 1 is.
Yeah, Mr. So and so, that is applicant appear for respondent number 3. There is still no appearance on behalf of respondent number 2. Awaiting the report regarding service of notice of respondent number. The matter is adjourned to.
May I please the lordship here?
One is the same.
Pending to refer one and other.
Yes, delegate. So and so has appeared on behalf of respondent number 3.
May I please the lordship, if your lordship allows me. Indian Bank is no longer a party here. Just in 2017 itself,
All right, so.
that loan has been taken over by the PNB.
What necessary parties have been served?
Sam.
Very good.
That PNB has to be made a party. Sir.
Just a minute. So and so has appeared on behalf of respondent number 3. The pleadings therefore appears to be complete. Let this appeal be listed on after 2 weeks under the heading admission.
28 July 20. Item 2 to 4.
This is 346 service report. Next. Rates for repayment.
Any matter pending before Supreme Court?
No, your lordship.
We see some order passed by Supreme Court. Watch out, this is the order with respect to transfer all cases.
Transfer the case before this.
So
Honorable.
have you issued notice?
Yes, your lordship, 25/2. Notice has been issued by this.
What's about respondent number 3, 4 and 6?
For writ appeal 3, 4 and 6, for WBC 7085, 4, 5, 6, 7, 9, 10, 11, 12, 13. There are 2 writ petitions.
Awaiting the service of notice and appearance of response number 3, 4 and 6. This case is adjourned to give or take.
Your lordship, my humble prayer to allow us for a justice service, your lordship. Under the instructions of my senior Hemchandra sir, senior advocate of the Manipur High Court, your lordship. To take justice service, because your lordship, we have instructions that they have received, but service report is yet.
All right. Prayer for justice service substituted. In 2 newspapers of circulation. Also dusty service.
And your lordship, may please be fix a date, your lordship. The next one, 18th of June, if possible, your lordship.
What is the matter about?
Your lordship.
My lord, this is about they are challenging the RR and as well as they have challenged the in order of the license for a promotion. Fine.
17th July.
Some dusty service.
July.
Awaiting the report in the awaiting the
17th July.
awaiting the service of notice on response number 3, 4 and 6. The matter is adjourned to so and so. In the meantime, the appellants are permitted to serve response number 3, 4 and 6 dusty as well.
And 3, with respect to which item number?
Item number 2, sir.
2 is fine. 2 years. I am representing 1, 2.
On the
3, 4 and 6 on list returnable date after 3 weeks.
17th.
Yes.
And for the item 3 and 4, 1, 2, 3, 8 has been completed. 1, 2, 3, 5.
First do this part, we will see.
Oblige, your lordship.
Item 5 and 6.
Respondent one bit.
This matter, my lord, my friend will serve the copy today, my lord. He has not served the copy.
You are appearing for respondent number 3.
Yes, item number 3, my lord. 5, my lord.
You have not filed wakalat.
Yes, I am respondent number, my lord, 3, my lord.
Have you filed your wakalatnama?
Yes, my lord, already filed, my lord. What? Yes, yes, yes. Yes, 1, my lord, 1.
Huh?
I am for respondent number 1, my lord.
That is one.
Yes, yes, yes. I think he's for 1
How
and
do you
3.
stand before the court without even knowing whom are you representing?
My lord, I am for respondent number 1. And my friend is for respondent number 3, my lord.
Ah, okay. ठीक है.
Mr. So-and-so learned advocate. So-and-so learned advocate submits that he shall be filing his wakalatnama on behalf of respondent number 3 today in the registry. In that view of the matter, all the respondents have been served and therefore this matter may be listed for admission on so-and-so date.
Interim orders are passed, but those may continue. They were interim orders, those may continue.
We are not interfering with that order.
Yes. No, no, sir, they may continue with them, sir. The interim orders may
Sir,
continue.
unless we assign it, unless we review it.
Look,
Sure.
look.
7-8.
Oblige.
7 to progress. Item 7.
First time.
May it please your lordship, my lord.
Yes. Yes,
Lord,
Mr. Das.
this is for continuation of delay, my lord.
More than 1,000 days.
1031 days, my lord.
Yes, what is the ground?
My lord, ground I have stated at para 5. And your lordships,
What have
and
you
I,
said?
my lord, basically in there are two contradictory situation emerged due to, my lord, division bench in one case allowing
Yes.
Actually, we have filed our these objection, my lord, that we will file. Actually, the grounds they have assigned in the page number 2, my lord, that is not sufficient. We consider for the continuation of delay, my lord. 1031 days of delay, my lord.
Sorry, Mr. Das.
My lord.
The conditions are not good grounds for delay. Yes, Mr.
my lord, may it please your lordships, my lord. My lord, only one thing, my lord. Similar matter, my lord, honorable, pending before the honorable apex court. My lord, in that line, my lord, we came to know about this only after the division bench judgment in that particular writ appeal, my lord.
All right, you take a judgment, let the order be passed from Supreme Court, then we shall see.
Only that much, my lord. Let the, because otherwise.
As prayed for by Mr. H.K. Das, learned senior advocate for the applicant, let this matter come on for consideration. Your date in August.
Mild,
1 and
much
2,
obliged,
obliged to lord.
10th of August.
highly obliged.
Item 9.
Service complete 1 to 11.
All the respondents appear to have served.
My letter, one submission is there. The entire matter will be heard by the CAT on 5th of June. On earlier date, my lord, the union has taken time. So we are ready to the final hearing on the 5th of June. So let the CAT decide the matter on 5th of June. Because they are against the interim order.
No, not interim, not you. Our stay vacation.
What do you expect this court to do? We'll fix it after 5th of June.
No, 5th of June, my lord, the matter will be decided there.
After 5th of June.
Does it?
After 5th of
Why does it take so long for you to register what the court has to say to your observation?
Sir.
You want it to be listed after 5th of June, you will list it after 5th of June. The pleadings are complete. Let this matter come up for consideration under the appropriate heading on June के third week, the second week.
All right.
This service is complete. Let this matter come up for consideration. The service, all the respondents appear to have been served. Let this matter be listed under the appropriate heading on
17th June.
Yes.
All right.
Item 10. 7.
May it please your lordships, my lord. In this case, it's an application for continuation of delay of 203 days, my lord.
Awaiting the service of notice on some of the respondents. The matter is adjourned to sort of 3 weeks.
Lordship. So far as, my lord, the respondent number 1 is concerned, my lord, we have already filed a dusty.
They have
Dusty
said some of
affidavit.
them. They have said some
Fine,
of
my lord.
them.
Fine, my lord. Fine.
1, 2, 3, 5, 6, 8, 9, 10. We don't know how many.
Fine, my lord.
That's all the
It's
respondents
You'll have to
said.
verify some return answered also.
I'll do the
Address
needful.
is not proper, all those things. Sir.
I'll do the needful, my lord. Much obliged, my lord.
20th July. Item 11.
May it please your lordship. This is a review application preferred by the state of Assam for review of the judgment dated 27/11/2025. We are basically agree because lordship has allowed our
All the repetitions.
Just. What order did we pass?
lordship was pleased to pass that order, the relevant portion at page 93, 94, paragraph 62. For the reasons recorded herein above, this court therefore finds that the eviction notices and reservation of land for a medical college are legally sustainable, and the question of rehabilitation has not been duly and fully addressed. The state as a moral welfare entity cannot push citizens into homelessness without due determination of their rights and eligibility for rehabilitation under applicable policies. Application of such principles does not undermine the public interest but strengthens social justice in the course of development. Consequently, while upholding the validity of the eviction, this court directs the state authorities, more particularly Principal Secretary, Government of Assam Revenue, and the Deputy Commissioner, Kamrup Metro, to undertake fresh individualized assessment and of rehabilitation claim of each of the appellants strictly in terms of the Assam Land Policy 2019, Settlement Rules and Regulation 1886. Such assessment shall involve proper verification of landlessness, indigenous status, socio-economic vulnerability, and absence of alternative accommodation.
It has not been contingent. Now you can proceed with the construction of the hospital.
Therefore, lordship will kindly come to paragraph 68.
Yes.
Taking note of the submission of the Learned Advocate General Assam, the construction of the hospital is already completed and the land occupied by the applicant is required for future expansion and ancillary activities. In our considerate opinion, ends of justice would be met if it is provided that till such determination is made, no coercive steps shall be taken to demolish the existing dwelling houses of the applicant. This is what is troubling us. Because subsequent development is there, that is one ground of review, lordship, which we are on.
Correct. We might review this. But then space 60, para 67, please have it. We will not allow a building to be constructed and then not be made
90 days.
of utility.
Till 18th of February, they did not approach us also.
So then they will not be.
No. Another thing is like this. Thereafter, they have given an affidavit only saying that they do not have any other land in Assam. Our whole case is because we have done this exercise and found that they are inhabitants of Bihar, Uttar Pradesh, West Bengal, and Manipur.
Check that.
We can reject it, and again they will come, a fresh cause of action will come up, and again another round of litigation, same will follow.
No.
Because we have already done it.
Agreed, Mr. Advocate General. It was on your asking. We are going to.
No, we have only said, lordship, that this land will be required. Now, what is the subsequent development?
We are inclined. We did not labor there.
No,
We are inclined.
not only this,
Look
had
at
it been
this.
90 days and normal situation or nothing, on 15th of March, this subsequent.
No,
That is the
we will not permit anybody to come in the way
will
of
be done.
construction and utility of a public building. We are
Not-
doing it. We will review it, but it will not absolve you of the responsibility.
No, we are not absolved. We do not want absolvement.
We'll-
We want to do that exercise. That exercise is going on.
Correct.
Is initially only 18 applied, then we made request, then you give us complete document.
Correct.
They have submitted.
In fact, if you had read a proper reading of paragraph 67 and 68
Lordship.
would have given you complete leeway. You have started the process, that's a separate process altogether. You had not to disturb them for 90 days. 90 days is over, finished.
If that clarification comes, nothing.
We will clarify. This is what we meant. This is what we meant. There is no difficulty, but we will clarify.
That clarification will be sufficient.
What the difficulty is this. Now, for review, we'll have to issue notice.
That is why, Lordship.
But we are telling you, this is what we understand. No litigation, you can proceed ahead. It'll be contempt of this court only.
No, Lordship will clarify because our submission was
Correct,
that
correct. Now we have a way out. We will dispose of this review petition without even issuing notice.
Lordship.
We'll only clarify there is no difficulty. The learned advocate general ought not to face any difficulty in making that building functional, because all that was directed was that the moment you start your eviction process, simultaneously you should also look for their resettlement. That process is absolutely different. 90 days, beyond 90 days, that will be separate. This you can proceed. If this clarification,
that is clarified, and for that, Lordship, I am also giving one handle, page 98. In our pleadings also, we have detailed thing.
Page
98. 98 of the review application.
Review is not yet registered. That is the difficulty. You have filed an IA seeking a leave to join all this writ petition. That is, review is not registered.
Because there are multiple cases.
That's why we'll have to allow this today.
If we allow this petition, then we'll be required to, and you will be required to,
Serve notice.
requisites for issuance of notice. That will take longer time. What you do is that file an application for modification of this order.
That is also filed. It is not that we have not filed.
But the moment you file your IEA, if we allow it, notices have to go. That will again take time.
Because
What we have
otherwise
predicted-
that technical flaw will remain. They may go to the Supreme Court, the other side.
That's why.
This is
No, regarding that procedural part, Lordship.
so. What do you suggest to this court?
Lordship.
What do you suggest?
My suggestion is that Lordship will allow our IA today and let all the matters come up day after tomorrow on Wednesday.
First of all, notice.
Because we want to find.
For tomorrow also, Lordship. Let it come tomorrow, Lordship.
Yes. Now, what is the prayer in the IEA?
And I have to seeking leave to elect common review, one review, because it was a common judgment involving many petitions.
Because it's a common judgment of about 20
Just
writ
a
petitions.
minute. एक second. Just hold on.
14, 15, 16, 17, 18.
We have heard the learned advocate general, who has submitted that under exceptional circumstances, the present IEA has been filed, perhaps for avoiding filing multiple review petitions with respect to judgment and order dated 27/11/2025, passed by this court in a composite manner in a number of writ appeals, the lead case being writ appeal number 311 of 2025. He submits that the state be permitted to file a composite review petition in all such cases. On query as to the reason for filing the review, the learned advocate general has pointed out that in paragraphs 64 to 69 of the judgment sought to be reviewed, the directions are not very clear, which are capable of, if interpreted in a different way, delaying the very process of putting the hospital which has been which has been fully constructed from being made operative. Made operative. He has further submitted that the construction of the hospital admittedly is for public purpose, and any further delay in its commissioning would frustrate.
Lordship, already commissioned, Lordship.
Just any further delay in the effective commissioning of the hospital would only frustrate the public purpose. It may be noted that certain lands appertaining to the hospital were evicted, were sought to be were removed from encroachment, which were to be used for making additional buildings appertaining to the hospital for effective administrative discharge of the hospital functioning. In that context, this court had directed while upholding the eviction process, that some effort should be made. That effort should be made for resettlement of the evictees, and for which a timeline also was given. The learned Advocate General has informed this court that the process for settlement of such evictees have already been undertaken, and the delay is only on account of their part of not coming up with clear information about their being landless. A survey also has been made, the learned Advocate General states, which confirms that many of them are from, many of such evictees are from neighboring states who are not landless. Seeing the totality of the circumstances, we find good ground for allowing this IA, for permitting the state to file a composite review against a composite judgment delivered in several of the writ appeals. Let the review petition be filed. Let the review petition be processed and be listed on. We give a date on?
Tomorrow, Lordship, if it is not in.
Day after.
Day after.
It's a big file. Day after tomorrow. Day after tomorrow or Thursday?
Thursday, it's a holiday. Thursday may be a holiday, Lordship.
Thursday?
Maybe a holiday, I'm not sure about it.
28th. Right?
Eid holiday.
Thursday.
If it is not a holiday, otherwise within
28th is a holiday. 29th.
29, Lordship, I am not available.
Then 27th. 27th. Okay, that we understand the concern of the state. We would always want the hospital to be commissioned in all possible manner.
Lordship,
Access road, everything. There nothing comes in
because
the
a nearby
But
hospital.
what we had directed you was different. We said that you must start the process, and for 90 days you must give the reprieve. If you have started the process, that 90 days stops counting. I don't think it requires any review, but then we will clarify.
Lordship. Because this will be handled for other cases also in all other eviction process, that they will take, that we occupy government land, then citing this judgment, they will come with the plea.
Mr. Advocate General, don't take it as a license for, throwing people to the vagaries of nature.
No, we do not.
Once you're evicting, you make a simultaneous process of settlement.
We have done identical things in, Mongoldoy. All were en masse rehabilitated. We have done the same in Kaziranga. Two villages we have evicted, we have given them.
Let our statements not be taken amiss. We are not asking for settlement of everybody. But settlement as far as possible in accordance with your land policy and for landless.
Yes, Lord. Absolutely, Lordship.
Nothing. We are not asking you.
Lordship has very clearly highlighted that also. Emphasis also is there.
Asking you to accommodate people from Uttar Pradesh or Bihar or West Bengal.
Or land with land.
Landless
With
people
land. Only
settled
landless.
here, you consider them because you are a welfare state. That's all. but the developmental process shall not be forestalled. That is for sure.
If,
And development process can only be stalled if it deals with, if there is some problem with climatic things, forest clearance and all that we are very clear. But so far as hospitals are concerned, public institutions are concerned, if you're not permitted that leeway to carry on your project, I think everything would be delayed.
12 bighas of lands are under encroachment in that prime area, and whereas the nearby hospital is being dismantled and everybody will come
But
here now.
clear reading of those paragraphs would make you know that you had to start the process and 90 days you have to wait. Finished. But then we'll clarify.
Highly obvious.
Item 12 and 13.
Lordship, we have to find affidavit, Lordship, sometime may be granted, Lordship. Lordship,
No, Mr. Advocate General, I'm so sorry. Please come. This is a matter which requires your intervention.
Yes.
At the level of the state. Now you have a policy. What is that policy known as?
Control order.
You have a something control order.
Lordship.
Generally, control orders are never couched like this. Section 17 says that if anybody who gets convicted, no notice is required. If he is a licensee, you just cancel his license. I think this provision does not collocate with the constitutional provisions, number one. Number two, this is a standalone provision which you will not find in any other state control order. And it has to be proved that suppose there is a fight between the family and there is a criminal case under section 323, 324. A licensee stands convicted because he is not having good relations with his brother. Should that be a ground for cancelling his license? And if at all it is, should he not get an opportunity of explaining his cause? The section says that without issuing any show cause notice, nothing, the moment a person stands convicted for any kind of offense, not also for offenses relating to the control orders or to a supply act, what is that called? Essential Commodities Act. Well, this is highly unconstitutional.
Lordship, I have gone through it the other time, and there was a very clear indication in the law. Today I am not prepared, so let me do it. Day after tomorrow, this also may. Otherwise, he has already got the relief. No.
We are not on that, Mr.
The identical case was already there earlier.
For different thing. Now, this requires a modification in law, which you can ensure. Not individual cases. We are not concerned with this. As long as your law remains, we will try to circumvent it in some way in which the justice is restored. But then you make a change in the law, which you can, it's a state subject.
I'll look into it.
It's a state subject. You just have to say,
Yes.
according to.
If there is nothing there, then I'll definitely have to modify it. There may be a overall scheme. Let me examine it once.
Or do it. We are not in a hurry. But it will avoid a lot of litigation, number one. It will be in consonance with the constitutional principles. Can you say today in 21st century, we are moving towards 22nd century, that a license given to you would be cancelled without even noticing? They use these specific words. No notice is required.
What is the rationale of that provision? Let me find out. Otherwise, basic principle of natural justice has to be followed.
Number one. Number two, if you test it on the rationale, then it goes, unless a person has been convicted under the Essential Commodities Act or for violation of any one of the terms of the license, why should that be part of some decision making which will take away his livelihood? Suppose 498 petition is going on. In a case of 498, he stands convicted. That dispute is between him and the wife. Why should it take away his right to earn his livelihood?
In my case, also 324 and 307. It is not.
I'll look into it and I'll get back to this honorable.
I put it after 2 weeks.
Lordship.
Please, your junior should remind you.
No difficulty.
Many matters.
Because there is another identical case where we had this is different.
That's the case where we had told you.
We have requested you also. This is the.
In this case. Anyway, Lordship.
I keep it after 2 weeks.
Lordship.
As prayed for on behalf of the state, let this matter come up. See, some state council had come on some other occasion and had said that we are about to come out with a order saying that in such cases, what should be done? Instead of doing this, there will be a definite kind of change.
It can be read down, Lord. If there is a complete roadblock, there has to be some way, some remedy.
Even if you come out with a circular which says that this is the way in which you have to
Yes,
follow
Lordship, this can be done executively also.
after 3 weeks.
Highly obliged.
19.6. Item 14.
Yes, Mr. Chowdhury.
Your Lordship, this is the second suspension under sections 6261C, my lord. But now I take to Lordship to page 61, my I mean, page 61 of the report.
Page 61.
61. Last paragraph, my lord.
Yes.
We came before Lordship on 25 to 26. By now, more than 5 months already have gone. my lord. In other than merit, my lord, I'm saying on that night.
Liberty is given to the
Yeah.
people to approach this court. In the circumstances, the said suspension order is extended beyond the 90 days of the ground of its reasonability and rationality. Mr. Chaudhary, they are.
No, I'm just other than merit, my lord, I'm just. Your Lordship.
No, that's what I was saying. This observation means nothing, paragraph 7.
Yes, that way it is not my lord imperative. my lord.
If the single judge has made a distinction between 6.2 and 6.1C,
Right.
which we also ratify,
Yes.
then here Ajay Chaudhary will come into play for the reason that if charges are not framed or it is continued beyond a definite period, what is this 90 days for rationality and reasonability? Do one thing, have the charges been framed?
Nothing, we did not start frame. Yes, start frame.
Then the law doesn't come in the way. In keeping
My
you
lord,
under
only
suspension.
question, your Lordship, what they have thought may reply. They simply say because earlier there are some lapses, so they have to go for second suspension. my lord. This is their case, man. Page 60, yes, well, page 64.
Like that, we are telling you, we are
My lord.
with you. Here the situation is that you were taken into custody.
Right.
If we remember correctly what you had argued and what we did not
Your
agree.
Lordship, what is there, my lord? Very good, earlier.
You were taken into custody, you remained in custody for more than 48 hours.
Right,
A decision was taken under section 6.2.
yes.
That was considered to be deemed suspension. That continued, you came before this court, the order was set aside.
Right.
Your suspension was revoked because it can't be for.
Revoke in terms of the order of this. court.
In terms of the order of this court and in terms of the judgment in Ajay Chaudhary, you would
Right,
not have kept.
right.
Now everything went fine, you were reinstated in job. They then decided that they shall initiate a departmental proceeding for you with respect to the offense for which you had gone in custody. Then exercising the powers under 6.1C for initiating a departmental proceeding, you were suspended. So this suspension is very different from the earlier suspension under 6.2, which was a deemed suspension. Unfortunately, it continued for a longer period than what was necessary, and the court had to intervene for revocation of such suspension. Now it will be governed by, so this distinction which has been made by the learned single judge, we are almost in agreement. Now the question is that it could have been revoked immediately if charges would not have been framed. Within what is the type? What is the section? What does 6.1C says? What is the requirement under the
Section 6. Section 2C.
4 months of child friendly.
6.
6.1C of the service, not service rules, civil service.
Some services discipline and appeal rules.
Service discipline and appeal rules.
Yes. 64. Oh. Should we hand over, my lord?
Service discipline appeals. Yeah, take it.
See.
And where is the provision concerning that it should be completed within which time?
Oh, that is not in this provision.
Then we go by this section 19. The observation made in paragraph 17, which is not in consonance with law, but nonetheless, Mr. Nayak, are you appearing in this matter?
I am not appearing, but I can appear, Lordship. I'm saying so because her brief is not with me.
How can you appear then? Would you
No,
be-
otherwise that issue, Lordship, once you have been suspended under 6.2, that has been,
He's not now invoking any distinction.
yes.
He is our introductory order on the last occasion makes it very clear. Now the impugned order, paragraph 17 says that be that as it may, liberty is given to the prisoner to approach this court in circumstances. The said suspension order is extended beyond a period of 90 days on the ground of its reasonability and rationality. Though this
Got it.
observation means nothing in view of section 6(1)(c), but you can't keep a person under suspension for a very long time, especially when you have started the departmental proceeding. They have started. Charge frame ho gaya na?
No, he has been posted at other office also, ma'am.
So no, in this case, whether charges have been framed or not.
Yes.
Departmental proceeding, whether you have been served with a memo of charge.
What I am saying, madam, because he was reinstated and posted in other office. So he has no access to this. That's what I am saying.
No, any memorandum of charges furnished or submitted, any reply filed
Yes.
in the departmental procedure.
Yes, to that.
So, Lordship, so far as this second suspension is concerned, Lordship,
No,
one
we are not
judgment.
on that. Why do you
Yes,
have to
Lordship.
waste your energy on something which is not in question now? He's not pressing that ground, Mr. Nayak. We don't agree with that ground. Even if he presses, we have already dealt with it. That's a different thing altogether. But would you wait for the entire proceeding to? You have to take a call. Would you wait for the entire departmental proceeding to be concluded? Or would you revoke his suspension if he's posted at another place? What purpose is it going to serve?
Lordship,
So
one
take a decision.
one rule 6.5 is there. If he furnishes, if he, makes a representation, Lordship, then authority may consider and take a decision. I'm just showing the provision, Lordship. It's 6.5. An order of suspension made or deemed to have been made under this rule may at any time be revoked by the authority which made or is deemed to have been made the order, or by any authority to which that authority is subordinate.
We'll ask especially Mr. Chaudhary, we do one thing. On principle, we don't agree with you. But we'll say that considering the liberty given to you by the learned single judge, you approach the departmental authorities and say that now that you have been transferred and 90 days, 5 months have passed, what to talk of 90 days, you are cooperating in the departmental proceeding. So in the meantime, your suspension should be revoked. File an application, they take a decision. If they don't take a decision, challenge that order. Go before the learned single. Then in that case, you can go before the learned single judge also. Correct? That's the only passage that we can give you now.
That's my reality also.
Take it.
Only a time limit might not be done.
We have heard Mr. H.R.A. Chaudhary, learned senior advocate for the appellants, and Mr. Naik, learned additional advocate general assembly. The appellant initially had questioned the impugned judgment passed in WPC number 195 of 2026 on the ground that the learned single judge did not consider appropriately that the appellant was suspended for the second time for the same offense, and therefore such suspension was bad in the eyes of law. In fact, next part. In fact, the appellant was suspended for having remained in custody in connection with a criminal case in terms of Rule 6.2 of the Assam Service Discipline and Appeal Rules 1964. This was an instance of deemed suspension on account of the appellant having remained in custody for more than 48 hours. Though a criminal case was registered against him, but there was no departmental proceeding either in contemplation or in existence. For some reason or the other, the suspension of the appellant continued for some time when he approached before this court.
Madam, may I clarify one thing? Madam? If your charge sheet was not in the first, madam, in the first suspension, in that case, my charge sheet at that point of time. Charge judgment. I'm sorry.
Charge memo or charge sheet में confuse मत करिए ना.
No, so-called notice along with the allegation that was given.
That time also for suspension.
Yes, madam.
Then where was
That's why I'm saying that that time it was given. After 90 days, madam. After 90 days.
the departmental proceeding चला गया?
Yeah.
You see that now persons can see that
So it isn't such a My lord, you was
strike it off. Strike it off. Just do strike it off. So that time only it has started.
Yes.
And departmental proceeding has not ended.
Not ended.
And what has happened in criminal case?
A criminal case is just initial stage one, nothing. Yes.
And
Appearance to.
see.
Yes. If I take your losses to page 41 in the first order, madam.
Where a case starting suspension. उसमें तो नहीं किया था. But not say No, Mr. Naik, I'm so sorry. There is a difference in this. Now, in this case, what had happened was, though of course it was a deemed suspension because of the arrest, but during the suspension period, departmental proceeding was initiated against him. Correct. So departmental proceeding was initiated, all right. Then there was a delay and the suspension order was revoked. After this, after some time, then 6(1)(c) is being revoked. Would it not be a continuation of earlier suspension? That's the question. I don't know why Mr. H.R.A. Chaudhary said
I'm
this.
sorry, madam, because I could not.
Committed
I
mistake
told
in
your lordship.
understanding it. Would that not be an extension? In that case, we'll be required to interfere with the order passed by the learned single judge. Just take a call and tell.
May I submit, Lordship?
Yes.
So far as 6.2 is concerned, therein also a departmental proceeding was initiated, but it was beyond 90 days. That is why court prepared to interfere in terms of Ajay Chaudhary and reinstatement was ordered.
This suspension would be under six, for what reason? The same situation was continuing then.
No. Earlier, Lordship, it was a deemed suspension. Now, Lordship, it is under 6.1c. If Lordship kindly see
Don't
6.1c.
put, Mr. Naik, we have initially, because of some confusion in facts, we were going by you. Look at this.
Yes.
Deemed suspension is deemed suspension for that period of 48 days. It was continued. It will be considered to be one in contemplation or in existence of a departmental proceeding. Now that continued for a pretty long time, and with the intervention of the court, it was revoked. Now you invoke 6.1c, which is not a standalone provision. So is it not a continuation of that?
I don't think so, because Lordship, that liberty has been granted by division bench of this honorable court, Lordship, in Ajit Chunwal, Lordship. This is WA 114 of 2023 or 24, Lordship. Therein the honorable division bench held that.
Either if Mr. Chaudhary does not agree to our proposal of his making an application before the departmental authority in view of the observation given by the single judge in paragraph 17 of the interim judgment, we will hear this thing. Are you ready for this, or should we hear it on the next day when Mr. Naik would come up with that judgment?
Then your worship.
Would you like to go? That's a better option for you, because more than 5 months have passed.
That is my, so your worship can fix only 1 week after 1 week. After 30.
But you can always make an application. You can always
That would again take, suppose they do not take an action, my lord. Then again I am to come here, my lord. Your personal suspension till matter for last more than 5 months.
I thought it is. No, this is being harsh, Mr. Naik. The way you have started it, you cannot continue it forever. And
Lordship.
then
But Lordship, if Lordship gives me an opportunity to, go through this matter and make our submissions before Lordship, that will be big. Because Lordship, this Ajay Chaudhary is a very contentious issue, Lordship, and there are many High Court, Lordship, they have already held that Ajay Chaudhary is not a binding judgment, Lord.
Please don't talk about many other High Courts. I have also seen 2 High Courts. The service rules are very, very clear in other High Courts, because these are service rules of later origin, where all these confusing areas, gray areas were taken into account. And then I can talk about Bihar service rules. It was not good, which was the earlier rules, but thereafter taking into account all the, relevant case laws.
Lordship will pardon me, but that is the only distinction, Lordship. So far as CCS rules is concerned, that is completely different from our rule, Lordship. That is the issue.
We will let you know, but we will say something today.
Lordship.
We have heard Mr. H.R.A. Chaudhary, learned senior advocate for the appellant, and Mr. Naik, learned additional advocate general for the state of Assam. The appellant was arrested in connection with case number ACB, PS case number 47 of 2024, and remain in jail for more than 48 days, for 48 hours. Invoking the provisions contained in Rule 6(2) of the Assam Service Discipline and Appeal Rules 1964, the appellant was suspended. It appears that during the period of suspension of the appellant, a departmental proceeding also was initiated against him, which is being continued even today. The suspension continued for some time. When the appellant came up before this court, seeking revocation of his suspension, on grounds of delay. With the intervention of this court, the suspension of the appellant was revoked. After some time, invoking section 6(1)(c) of the rules of 1964, the appellant was again suspended. This was questioned by the appellant on the ground that this is a second suspension with respect to the same case, which contention was not sustained by the learned single judge, holding that the earlier suspension was under 6(2) of the rules of 1964, whereas the present suspension is under the provisions contained in section 6(1)(c) of the 1964 rules. However, while dismissing the case of the appellant, the learned single judge had clearly observed that if the second suspension of the appellant continued beyond 90 days, he would have the liberty to approach the court again, questioning such continuance of suspension on the grounds of rationality and reasonableness. The issue raised before this court in the present appeal is whether even during the deemed suspension of the appellant, after his custody, after his remaining in jail for more than 48 hours, if a departmental proceeding was initiated against him and the suspension order continued, then such suspension would not be a deemed suspension, but would be a suspension under section 6(1). For the continuance of the suspension during the pendency of the departmental proceeding, with the intervention of this court as noted above, the suspension was revoked. The question raised by the appellant today is that after the appellant was transferred to another location, that is a location different from where the departmental proceeding is continuing, could the provision contained in 6(1)(c) be invoked to again put him under suspension without there being any definite ground or reason, namely of his tampering with the evidence or of his not cooperating with the departmental proceeding, or of his conviction in the criminal case in the interregnum. The learned single judge, as has already been noted, made a distinction between two kinds of suspensions invoked under sections 6(2) and 6(1)(6)(1) respectively. Gave the liberty to the appellant to approach the court again for revocation of suspension if it continued beyond 90 days. More than 5 months have passed when the appellant still remains under suspension. This does not answer the issue whether the suspension for the second time was in fact a second suspension without any valid reason. Mr. Nayak, learned additional advocate general, submits that he shall assist this court on the next date on the issue. Let this matter come up for consideration on whichever day, tomorrow, day after tomorrow, 1 week, 2 weeks, tell us.
Tomorrow, after 30 any date, mother, I will be out.
No, I'm asking Mr. Nayak. He has to.
If possible, to charge you, man.
Lordship, in the first week, Lordship, June, in the first week of June, any date, Lordship.
Third June, madam.
3rd June.
Obliged.
I only request my learned senior colleague to furnish me a copy of the appeal, Lord, through your Lordship.
Yes.
Do it today, Mr. Chaudhary.
Yes, madam.
Obliged, Lord.
Obliged.
Item 15.
The appeal is regarding the OBB teacher for pension. A similar issue was fixed on 16/7/2026. for filing.
See it with another case,
Yes.
they all list. You have supplied. List this matter along with so-and-so, which is slated to be listed on. Which is the date?
16th of July, my lord.
16th of July.
The lead cases, my lord, read appeal 258 of 25.
Take the number. Correct.
Much.
I'm so obliged.
Please, Lordship. Lordship, I may be served a copy of the appeal, my lord, because I have gone through the records. The copy has been served to the earlier councilman.
Sir,
PTC. I'm deeply obliged.
this request you could have made without the intervention of the court. You could have requested the council. No?
Yes.
Item 16.
Yes, Mr. Bora.
Yes, Your Lordship, we have filed an affidavit and we have issued a clarificatory order saying that this particular, we have decided not to continue with his services because we are not going to extend it, just that, not mentioning any other reason. Your Lordship. Subject to your Lordship satisfaction.
My lord, in the affidavit, my lord,
Where have you filed the affidavit? Is it here?
Yes, Your Lordship, it's on, I filed it on 21st of May.
Page
Lordship,
131. Yes.
Page number, Your Lordship, starts at 137.
my lord, in page 141, raised made contradictory statement.
When you file?
21st of May.
The affidavit filed on behalf of the respondents is not on record. Let the same be placed on record and let this case be listed again on Friday. Friday.
29.5.
Right.
15.
September, the detailed order.
Yeah.
Everybody else is appearing, Mr. Thakur is appearing.
Yes, Mr. Boyan.
My lord, I'm sorry, my lord. I am, my lord, may I pray for my lord, short accommodation of this matter on next Tuesday or
We can give you a decent burial of this case. I mean, decent quietus to this case.
my lord,
Adjournment.
my lord, because
Or
I have,
whichever reason the advertisement was of the year 2000.
that is correct, my lord, that
There
is
is nothing
correct.
on record.
My lord, what has happened, my lord, we were,
Can there be a judicial order of any kind which is sustainable order of giving you appointment with the government, especially in police force, after 26 years?
no, my lord, that's the,
Agreed, the authorities were not very careful in keeping the records. There is
No, my
nothing
lord.
on record and they say that everything has been burned.
my lord, I, with
They
all
have not shown
respect,
any proof.
my lord,
Do you want-
my lord, with all respect, my lord, what my lordship has put the query on me, my lord. I have find out few judgments, my lord. Not up to the 100% that I can make satisfied you,
There
but I
cannot
will.
be, Mr. Boyan, let me be very candid.
My
Don't
lord.
don't take it amiss. We don't say that we know all judgments or we only think rationally.
No,
Can there be any judgment? Can
No,
there
my
be any judgment in the absence of records after 26 years?
No, my lord, no.
Employ
It
400
is,
persons.
my lord, it is not only record, my lord. It's the learned single judge, the speaking order which they have held, my
Mr.
lord.
Boyan, we are aware multiple writ petitions were filed, many
My
were
lord.
dismissed. At one point in time, somebody said that they have their claim has some substance, it can be inquired. On the basis of a solitary statement by an officer who acted in a most irresponsible manner, the whole thing has been re-agitated. After 26 years, even if there is a record, we are not going to do anything.
Then my lord, make fixed it on Tuesday, my lord, coming next week, my lord. I will appear and I will, my lord, physically, my lord, I will make last attempt to satisfy my lord, my lord. Just this is the last request, my lord, on next Tuesday. My lord.
As it forward by Mr. A.R. Boyan, learned senior advocate for the appellants. Let this matter come up for consideration on whichever date you say.
My lord, on next Thursday, my lord. Next week, Thursday, my lord.
You know, this bulk should be removed from the records of this court.
My lord, my lord. I am highly obliged, my lord,
4th June.
for providing. My lord. Obliged, my lord.
Item 19.
This is the PI again for the
The cleaning exercise is over. The repairing of the washroom was going on, my lord. And thereafter the painting of the wall will be done.
When will you throw it open to public?
Yes.
When?
My lord, it will take around 3 weeks now because the moment.
We give you 4 weeks, throw it open to the public.
That will be done.
My lord will keep it pending and let it be listed after 4 weeks.
Mr. S. Bora, Learned Standing Counsel, GMC and GMDA, has categorically stated before this court that the facelift which was being given to Silpukri Park is almost at completion, and the park shall be thrown open to the public within a period of 6 weeks. Within a period of 6 weeks. We are giving you 3 more weeks. Come and create a situation whereby he withdraws his petition. Stop. In that view of the matter, let this case be listed for consideration on July 15th. After July, after 15th.
29.
Obliged.
Item 20 and 21.
Within item 20 and 21, I need 1 week more time. I need
Mr. Nath,
1 week more time.
Mr. Nath, torrential rains are on the annual. Torrential rains. Today is the orange alert. Next 2 days, it is red alert. We don't want to hear any life lost in the drain, in the open manhole.
They are doing, they are working. They are working. I'll file an evidence.
There is a witness who can be asked any time whether the manhole in front of his house is closed or not.
That is, I have inquired. I have sent the people that is actually there.
What do you want with this?
It is an open drain, Lordships, in front of Lordships premises, the building. That drain is an open drain,
No, Mr. Nana. In front, next to my building, that is one left side of the road is an open drain, small drain. I'm not saying about that. In that building opposite to my other side of the road, 2 manholes.
No, you can't. Whether it is before Justice Chaudhary's house or before Mr. Nath's house. You have to close all manholes.
Yes.
It sounds rather, it will be very tragic for us to hear again that somebody, got flown inside the open hole and then he dies and his dead body is recovered, say 25 kilometers away.
This
is something which cannot happen in a city.
Absolutely. We are trying not to happen like that. I have instructed my agents to go there. They have visited. They have visited.
That is the difficulty. No application of mine, no sensitiveness.
No
because
sense.
somebody says in front of Justice Chaudhary's house, so they went to Justice Chaudhary's house and there was an open drain. So that is your satisfaction.
I have instructed them to see.
Open manhole.
I'll see.
I'll see justification anywhere, Mr. Nath.
I'll tell them again. They are Lordship, I'll take care of it.
It'll be a disgrace for all of us, all city dwellers, if it happens.
Lordship.
It'll be a disgrace for us.
Absolutely.
He's witnessing one day every day.
We are thinking for smart city and this is the position.
Mr. Nath, while going home, just near the JBs, look at that.
Can I get the photograph?
I was traveling last evening. Somebody was coming. A person told me that
very serious photographs.
Just a minute, Mr. Nath, you must hear this. While I was traveling, somebody started chatting with me in the crowd. And he said that, the difficulty we face today is that because the senior officers and others, their houses are located at good places, they don't feel the difficulty. We feel it. We feel the difficulty. Then he wanted to inquire who I was. And I deliberately, out of shame, I kept quiet. I did not disclose my identity. And this concern of people this grievance of people is, it's warming up.
Malad, we are definitely, Malad,
There are three kind of brain, my lord. Lordship, may I
our
clear-
officers have taken it seriously.
We are trying to do it.
But
No, it can't be remedied overnight, but
Absolutely.
no life should be lost, please.
Malad, Malad, absolutely, this is not adversarial, Malad, we are taking it seriously, Malad, I have instructed and they are also.
When do you want us to take a stock of the situation? Next,
Lordship.
when?
Malad, Lordship may give us 1 week time, Malad, let us have a report and I'll file the affidavit, Malad. Let me come up with the report, Malad.
Next 2 days going to be heavy rains.
It's raining, Malad. Correct.
We are not happy with this. Gigantic efforts will have to be undertaken, gigantic efforts.
But efforts are on according to them. It's not sufficient.
Yeah, the
I do
manholes,
agree.
Karina.
It's not sufficient.
Drains, desiltation, scrapping, these are long-term measures. First, you close the manholes.
Malad, they're Malad, in fact replacing, doing it, Malad, and a process is going on. Process is on, Malad.
Either it should be covered or necessary arrangement should be made.
There are two photographs. One is Adgaon, one is Jevis, my lord. Next one is Jevis.
Which is this page?
Give copies to him.
Yes, my lord. I have understood.
Okay, at the request of the not letters, legal but advocate assent, the matter, both the matters are adjourned to. They're giving you 2 weeks, please, ensure that nothing happens.
Well, item number 37, that PL pertain to the entire state of Assam, where different district also facing the same kind of problem. Lordship on 12/5/2026, Lordship passed a direction. Similar direction was also given here, madam. It was all the main host.
Supplementary.
Supplement 37.
37. Here we have, my lord, prayed for, my lord, some situation also similar occurred in Silchar, my lord, Nagaon.
You respond to this also. They're keeping it after 2 weeks. You respond to this. Let this case be listed along with so and so.
Well, in fact, in this matter, a lot of respondents
In
are
which
here.
the response affidavit of the state shall be filed.
Well, I am referring for respondent number 2, 5, 6, and 8.
Response
Other
affidavit
responses
on behalf of so and so shall be filed.
2, 5, 6, 7, and 8.
So they are the major party, my lord.
Actually, next.
You can collect the information from.
19/6.
Next.
Public.
Lordship,
Lordship.
Lordship in PL number 37, issue has not been served to respondent number 5, ASDMA. May you, sir, kindly send a notice to the registry?
Don't worry. The response of Mr. Nath would suffice. Don't worry. We'll look for you only when it is required. Look for respondent number 5 only when it is required. Don't worry.
Public.
Yes.
Item 22.
May I please, Your Lordship? In this case, Your Lordship, we have to challenge the cabinet decisions dated 5/2/2025 on the implementation of section 12(1)(c) of the 2009 Act, Your Lordship, Right of Children's Free and Compulsory Education Act 2009.
Question then.
Lordship, since Your Lordship, Your Lordships may kindly come to page 37, Your Lordship. That's an additional affidavit in a pending proceeding filed by the state. What?
Dealing with a matter where.
Yes, that's also there, Your Lord.
It is listed.
Both are listed. In fact, if your lordship recalls, your lordship indicated on the last occasion that because of that cabinet decision is not challenged, we are taking all the steps for the non-mandatory unaided schools.
Respond to this.
Yes, my lord.
You respond to, in the meantime, have you done something for students?
My lord,
No, first
If-
of all, your
before-
lordship, they have kept it confined to vernacular schools.
That's right.
That's-
Yeah,
that's-
for the
Lordship.
putting the local language.
We are aware of that.
Lords.
The Lordship is aware of the thing, and my lord, in fact, my lord, before this PIL could be filed, since your Lordship already directed and taken up the issue, my lord, in the affidavit that we filed in the pending petition, we have already indicated that we are aware of it and we are taking steps to modify that.
When? After the session is over?
No, no, my lord, after
Next
your
year?
Lordship, after. My lord, we'll be done very soon. My Lordship will kindly see, we have already indicated.
On this while we were accepting the situation that the government is in a fluid state, elections are going on. Now that the government.
now
has
it is so.
formed,
Yes.
I think.
Yes,
should
yes.
address it.
My lord, we have very clearly indicated.
What have you done for those students? Have you given direction to all the schools
Yes,
that
yes.
they must register?
Yes,
Have
yes.
they come out with vacancies?
My lord, I have given particulars here. So far as there is a complaint that there is some schools could not register.
Ms. Verma, you have that affidavit?
I have not.
What is that? Mr. Kothakul, we'll look at it.
Lords.
Just hold on for a minute. That is urgent. This we can handle.
Lordship, we have filed a reply to that affidavit which the state had filed, Lordship, and it is on record now. We called it this morning. So Lordship, they have confined that affidavit only to vernacular schools, nothing apart from that. One direction which, and this is a repetition of that to make awareness, to send out to the districts that the 12(1)C portal is open. It is only one direction and it is a bunch of things sent to all the districts. There is nothing new in that, Lordship, not a word new, nothing about 12(1)C. They have completely bypassed the whole process. And in fact, Lordship, they are relying on this court's order saying that by the orders of this court, they have gone further. Lordship, may kindly take up my affidavit, which is on record today, Lordship. We filed it. Lordship can have my copy. We have already called it, Lordship.
We'll take it up tomorrow.
Lordship, both these matters may come up tomorrow, Lordship.
This and the other matters.
22 and
Both our PIs may come up tomorrow, Lordship. And Lordship, another thing which why we came early this year, we have been agitating before this court, Lordship. This year, academic year is also gone for the children, Lordship. March was the date. Now we are in May. I have been before Lordship for the last 2 months. Last 2 months, nothing has moved. The list they came up with 885, it does not concern me at all. That is for vernacular schools. That is not my prayer. They have completely brought in a new challenge in my PI, Lordship. Instead of going with the 12(1)C, they have brought in something new, bypassing the whole act, bypassing the whole memorandum, their memorandum, Lordship. And only in 23, we could manage 41 children to get admission. After that, till date, we are still before this court. We have not been able to do anything, Lordship. And every date is a new excuse, a new ground, Lordship.
Your case is at which number?
39, Lordship. 32.
32,
Lordship.
Let the IN number 39 of 2000.
32, yes, 39.
39 of 2026 and the IN number so
30.
be listed together. On tomorrow? No.
Yep.
Next.
Yep.
27.
Much obliged, Lordship.
Item 23.
Make legal lordship. My lord, the present PL has been filed, seeking restriction, certain
You're a
restriction.
lawyer, you're a student.
My lord, I am a lawyer practicing. I got my license in 24, graduated in 2022. My lord. My lord, this PL has been filed seeking restriction, my lord, on certain kind of a social media content, which is been produced by the social media
It's
content.
not the appropriate time. Now, legislation is coming. The parliament is thinking about it. This we can't do.
In high risk sensitive domains.
Make it restrictive. This is not the body which will decide about this. No, who decides? Up till now, I have not been able to understand how can a person be an influencer? Now, what restrictions would I place? Would we place? What influence? Suppose somebody plays a reel. And you say that this is the content is influencing content. I don't understand. These are meant for fun.
My lord, these are highly sensitive domains.
Respond, what is prayer? We can understand the concern, but you have formulated it by way of public interest litigation.
Some distribution, because my lord, health
Rapid and
medical.
growth of social media influencers and content creators. That is a new business. People earn lakhs and lakhs out of it. You want us to put letters on that, on their creativity.
My lord, it has become an ecosystem currently, my lord. It's all become a number game, my lord, in highly sensitive, my lord. I'm not seeking other domains, my lord.
Concern us. That's the whole question. And why the society would be concerned about this? It's a matter of number. People like a reel, people like a content, they make they become a follower, the number of follower increases, the man earns. Now, usko hum kya karenge?
My lord, in respect to medical, health, law, or education, only in specific high risk sensitive domains, my lord. There are people who are seeking giving real estate advice.
What guideline do you want?
My lord, certain regulations, some committee may be formed in respect to.
Friendly's petition, but it is a petition which does not require our attention at the moment. Wait for a legislation to come.
Some qualification, my
This
lord.
can't be done by a judicial intervention. Monetize videos, reels, posts.
High risk sensitive domain, my lord, without any qualification.
A peculiar petition has been filed before us under the rubric public interest litigation, highlighting that there has been a rapid and unregulated growth of social media influencers and content creators who, according to the petitioner, gives advice on screen on issues which are highly sensitive and fall in the technical domain of health, medicine, nutrition, finance, law, education, real estate, child welfare, etc. The grievance of the petitioner is that there is no regulatory mechanism to ensure that only people competent to advise or influence must be allowed to display their content before the public at large. Who? Public at large. According to the petitioner, such content creators on these sensitive aspects of life do not have any formal qualification, degree, or license. There is, it has been asserted, no regulatory oversight. There is yet another grievance of the petitioner, namely that these content creators who are beyond any regulatory mechanism of the state make money out of the number of followers. What is questionable is that these content creators slash influencers get projected, because of a large number of followers, as professionals, which possibly could misguide the gullible viewers. The concern of the petitioner is that with this unregulated content creation and its display, the respectability of the professionals in the respective domain slash fields would be considerably eroded. Few of the examples cited by the petitioner is few of the examples cited by the petitioners are legal influencers who may be giving advice without them being law graduates. Similarly, there is a possibility of even unregistered real estate brokers influencing or promoting unregistered projects or lands which are in dispute. So under such circumstances, the prayer of the petitioner is that the state must be directed to regulate or restrict such unqualified influencers in sensitive fields and make it incumbent upon such influencers to disclose their qualifications or credentials. There ought to be disclaimers in such projections. If it is meant for entertainment. The concern of the petitioner cannot be called to be frivolous, cannot be stated to be frivolous. But the issue before us is whether any restriction on this kind of content creation would be possible without impinging on the right to free, without impinging and violating the free speech, the right to free speech, or the protection, right to free speech. Regulation at all levels is required, but whether this would be the forum for deciding is what is troubling us. the petitioner would be well advised to approach the welfare department of the government to take necessary action in this regard. The concerned departments of the government to take necessary action in this regard. With the aforementioned observation, we dispose of this.
Much of it.
We'll come back after 10 minutes.
Item 25.
Yes.
May it please the Lordship, in this matter, my lord, I'm appealing for the respondent. A copy of the memo of appeal has been served upon me today, my lord.
How is that possible? It's coming for the first time.
It is coming for the first time. There was a delay condemnation, my lord. That's why I have come to appear, my lord.
No, that is condoned, my lord. Delay condoned.
That is for delay.
It is
That is why.
Just give us a minute.
Nice.
It's 82, 26.
What is the policy of reimbursement of
There is
medical
no,
expenses?
There is no policy as such, my lord. We are required to provide the treatment, whatever is given in the Plantation Labor Act, my lord. We are required to maintain a garden hospital in the garden. And whatever treatment is there, my lord, the garden is to provide me.
No, that's all right. Suppose somebody is facing suffering from cancer.
There is no
Some
policy.
treatment. No, but there must be some policy for covering the expenses.
It's a private employer, my lord. So there is no policy as such.
A private employer is all right, but then you are a big, tea grower.
I'm not a big tea grower, my lord.
You or anybody, you may not, Mr. Dekai, you may not be a good big tea grower, but your stature is compared with the employee.
No. May I just clarify? My lord, there are two types of gardens, my lord. Depending on the workforce, my lord, one, the estates are required to maintain either a group hospital or a garden hospital. I fall in the category where I'm required to maintain a garden hospital, which is much smaller in scale, my lord. A bigger garden is required to maintain a bigger hospital, which is a group hospital. There it sometimes also happens, my lord, that the district civil hospital, there is a tie-up with the district civil hospital. But here there is no.
The amount is only 2,10,000.
It was in 2014, my lord. If that is stated as a precedent, my lord, then.
Let's see what, are you ready? You have not got the memo. No, this, on what ground has the court, has the 11th single judge, it's the longest judgment. He has interfered with the award.
Has quoted many things, my lord. Lordship may come to page 51. Just now, the finding of the learned labor court is that we could not provide treatment for cancer. 52 is the relevant paragraph, my lord. Middle paragraph. May I read, my lord? I have
Just. First to be heard. It still is in employment.
No, in 2012, he retired.
He has retired, but this is with regard to his wife.
And we have followed where.
He has retired. He has retired.
In 2012, he retired. Okay.
Now we'll go on a different issue, Mr. Decker. We are just forewarning you. Under section 10 of the Plantations Act, the employees and their wives would deserve treatment. So, now if they deserve treatment, cancer treatment is not available. It is not a continuing expense. It is a matter of 2 lakhs. Because neither in the garden hospital nor in the company hospital was there any provision for treatment. He had to take his wife to Bombay. When I get into all these legal juggleries, let us see. Here, we'll be diverting our gaze to a different topic, which doesn't have a lot of relevance. We would like to sign the trial. Let's see. You take instructions and tell us. Let this not be a precedent, but you can stop this.
Anything Lordship will
See, let us apply our minds how to dislodge this position of the saying that interfering with an amount of these 2 lakhs only. That also for a cancer patient. And agreed. Agreed, it has to be within the parameters. There is no, I mean, for it to be judicially enforceable, there must be a right. Sympathy cannot always dictate terms. We understand that. But, let us see. Give him a copy of
I have received the copy.
I have already
I have
given.
received the copy.
When will you respond?
Lordship will fix it up in next week. Because if I have to respond by way of an affidavit, then Lordship will give me 10 days time.
So you can argue otherwise. Appeal me what your response.
Maybe on Monday next, my lord.
Monday next. At your convenience.
Can you give 8th, my lord? 8th or 10th?
No, why not?
10th.
Just.
You have heard
On 8th.
MS.A. Bhattacharya. Your Abha Bhattacharya. You have heard MS. Abha Bhattacharya for the appellant and Mr. N. Decker, senior advocate for the respondent / Messrs. Kapo Donga T State Private Limited and others. One Anil Saikia, an ex-tea garden worker, sought reimbursement of medical expenses for his wife's cancer treatment from the respondents / employer. The wife of Anil Saikia had been diagnosed with cancer in the year 2008. The patient was referred by the tea garden management to government hospital for her treatment. But when her condition worsened, it was advised by Gauhati Medical College Hospital for specialized oncology treatment, which was not available in Gauhati. The claim of the appellant is that on verbal approval from the garden manager, the patient was taken to Bombay for treatment, to which she favorably responded. The medical expenses came to approximately 2,10,810. Which was refused to be reimbursed by the respondents. The issue was referred to the industrial tribunal, which ruled taking into account the humanitarian aspect as also the obligation of the employer. That the management must pay the medical bill, covering the expenses incurred by the employee. The award of the industrial tribunal was questioned by the management, which objection was sustained. The learned single judge by the due judgment opined that there was no legally enforceable right of the employee against the management of covering the medical expenses outside the state of Assam without formal prior sanction or approval. The court also held that medical expenses outside the state of Assam, covering medical expenses outside the state of Assam, will not strictly fall within the statutory obligations of the employer. Mr. Decker, learned counsel for the response, learned senior advocate for the response shall respond to the petition by the next date. We notify on. We are giving you up to 10 days in case you want to put in any written submission, you can do. Otherwise, they'll hear you.
8-6. Item 26.
Please, Lordship. Lordship, I'm on behalf of my senior Mr. M. Chandra, Lordship. M. Chandra. Lordship, he has some.
ST, who appears for the other side? Union of India, Mr.
Yes, and it's the main party, Lordship.
What is the
Lordship,
position
we
of,
have.
once the benefit is given, can it be reverted? Can it be taken back? With the status of ST vanishing,
Yes.
no notification, can the advantage which accrued to a person be taken back? नहीं आप देखा नहीं है. Anyway, she wants time. Get ready in the matter. It's a question which should beg an answer. Again, as prayed for on behalf of the petition and agreed to by the council for the Union of India. Matter is adjourned. When do you want it?
Lordship, after 2 weeks.
22nd July. Item 27.
In pursuance to this last order, the state government has to respond that matter to the order. Regarding
Yes, you are supposed to respond. Working plan for forest.
working plan, without working plan, it is matter 21 is given.
Nothing can be done.
We have received, my lord, a detailed report, 1 week's time.
How many times take time on that ground?
The last order of lordship was communicated, my lord. The department has accordingly prepared a response.
Details written in the last program.
The test is. Mr. Mahanta, the matters are being moved. There are 10, 11 divisions which do not have any plan.
My lord.
10 divisions have their plans. But out of them, 4 are at some stage, 3 are.
Stage
at
1,
some
stage 2, stage 3.
Like that. What do you want?
For 11 divisions, we have taken some steps. We will bring it on affidavit, my lord, a week's time.
Mr. I. Thakur, at council for the state, submits that updated report shall be filed by way of an affidavit by the next date. Re-notify on something.
Developed.
Apply.
Developed.
12 August. Item 28.
I'm at 33.
33.
Because the complaint let.
Yes.
Last quarter, the Milord has passed an order on 28/7. 28/7. Detailed order has been passed.
Just.
My lord.
Yes. What happened in the meanwhile?
My lord, on that basis, lordship subsequently directed the bank also to file their affidavit. They have not filed yet. They have not
Who appears?
yet.
Are you appearing? Somebody is appearing online. Unmute yourself.
Yes, sir. I'm for the revenue department, your lordship.
No, she's not the important part. The bank's name is not shown. Because sir, I'm taking care of this. Please.
Respond number 3. Who appears for respond number 3?
Last occasion, before the last occasion, they have taken time to file their
Who
response.
appeared on the last?
I'm Sharma.
I'm Sharma. Sharma. Sharma could pose the thing.
Mr. Sharma was here, I suppose.
His name is not reflected.
Be careful. The respondent number 3/bank has been served. However, it appears that today there is no representation on behalf of the respondent number 3 for the ground of the name of Mr. M. Sharma not being reflected in the court list. Let this matter come up for consideration on next week. And the name of Mr. M. Sharma must be reflected in the cause list next week, or the next Monday. Also inform Mr. Mazud. Third party purchaser.
Item 29.
Yeah, 29. If the second petition,
Lordship, this has been settled by the Honorable Supreme Court.
okay,
It has been settled.
what has, what?
They are in.
They are in.
They are. I'm giving a copy of them.
That's good. We had a very, very different view.
Yes, Lordship had a different view. Lordship may see paragraph 43, 44, 45, Lordship. That your Lordship will find in page 27. The page numbers are below, Lordship.
Page 26.
Page 27. Page numbers are given below, Lordship. Lordship will see paragraph 44 onwards. The condemnation is allowed to 1 year, and they will be entitled to the second service pension also, Lordship.
Can you have the judgment of the Supreme Court?
He had a shortfall of 10 months, 2 days, Lordship.
Are we required to give facts? No.
Not at all, Lordship.
Some facts we'll say, otherwise.
I was on a different track, Lordship, because the original judgment was passed in view of the Navy Act. So this is still uninterfered.
Has to be ordered on. The sole respondent. After his retirement from Indian Army as an electrical mechanical engineer, come on, got telegram from? In the year 1979, enrolled himself in the Defense Security Corps in the year 2005 and served in a second innings till his retirement on March 31, 2019. Totaling about 14 years, 1 month, and 28 days in the Defense Security Corps. He claimed his entitlement to a second service pension for his Defense Security Corps tenure under Regulation 125 of Pension Regulations in the Army, 1961. Notwithstanding the shortfall of 10 months and 2 days from the required minimum 15 years of qualifying service. The prayer of the respondent was denied by the administration, which led him to file an OA before the Armed Forces Tribunal. It was claimed by him before the tribunal that their shortfall must be condoned. Such prayer was opposed by the department on the ground that the respondent was discharged under the army rule and received service gratuity and death cum retirement gratuity instead of pension because of not meeting the 15-year threshold under the revised regulation in that regard. It was urged before the court that urged before the tribunal that by virtue of various circulars, it was clarified that there can be no condonation of a second pension, condonation of shortfall for second pension, as it would only give dual benefits. The condonation is intended only to ensure that at least one person condonation is only to ensure that at least one pension to an individual must be paid who might otherwise be left without any pension. The tribunal, however, allowed the application of the respondent and directed for condonation of the shortfall of 10 months and 2 days. And also directed for issuance of a corrigendum pension payment order for the second pension of the respondent from the date of his discharge, and all payment of arrears within 4 months with 6% interest on default. While saying so, the tribunal relied on the decisions, erstwhile decisions of the tribunal. Mr. R.K.D. Chaudhary, learned senior advocate slash Deputy Solicitor General, submits that he does not press this writ petition challenging the order passed by the tribunal in view of the judgment of the Supreme Court in civil appeal number so-and-so of 2026 arising out of diary number so-and-so of 2023 in Union of India and others versus Balakrishna Mullikkote, in which it has been held
Lordship is the paragraph 48 of this.
that if upon in which it has been held that if upon determination of the length of qualifying service, there remains a shortfall of 1 year or less, the employee shall be entitled to seek condonation of such deficiency for the purpose of pension eligibility in accordance with paragraph 125 of the Pension Regulation 1961 or paragraph 44 of the Pension Regulations 2008. Of 2008. The Supreme Court also was of the view that second pension is a distinct right which is separate from the first stint of the employees in the regular army. If that be so, then condonation of shortfall in Defense Security Corps tenure would not be against the scheme of the army regulation. Semicolon, rather it would be entirely inconsistent, entirely in accordance with the scheme of the army regulations. This writ petition therefore stands dismissed as not pressed. What judgment? We are retaining this copy.
Yes, yes, Lordship. In fact, perhaps the issue which I have raised before the Lordship
was different.
No, because it was set aside in the Navy Act. The Army Act is still unintercepted.
My view is here different.
But we are bound by this decision.
In fact, if this decision was not, I would have decided to. Whose service you can continue. Two pension is bad.
My lord, rule is very clear.
Anyway, Supreme Court says why do you have to
Rule,
continue?
rule also said, my lord. 174 rule also said.
It's all right.
Obliged, my lord.
Item 30.
Well, this is regarding renovation of the road, Malad. My
Yes.
instruction is that this road has been kept in the priority list and the estimate has been sent by the respondent number 4. The estimate is sent to the respondent number 2. The budget is fund has not come. Malad, the Lordship may I would pray that Lordship may keep this matter after one month, Malad. And in the meantime, that process let the process be go on, Malad. It is otherwise in the priority list, Malad.
Was this entertained by this court for the first time?
No, Lordship, it was before court number.
That's correct, but my view is different. This cannot form part of public interest litigation. One road repair.
Lordship.
I mean, we can't direct for this. My understanding of public interest is something else. Road is all right. We will take stock of the situation, but then could it qualify for our determination as a public interest litigation?
Since they are proceeding, Lordship, we are.
This is their proceeding. Therefore, we are not saying it.
We are expecting some
I was
positive results.
a little surprised with this kind of a prayer. I would have said something, but definitely not entertained the petition. We have told this only for saying not that this entertaining of this petition is bad in any way. But the views of the court should be applied across the cases. I mean, this is my view. If it is for one road, I'm not taking it up. Then it is a personal interest. I'm not telling any. Now that he has taken personal interest means that it is only with respect to one road. I'm not concerned. We are not using Article 226 for this. I'll go for the entire state of Assam, or maybe a region, but one road, one thing, the road in front of the Chief Justice's house. This is not, to my mind, PIL.
Lordship.
Correct. I mean, let me make this very clear to you. So if Mr. Nath has proceeded on that, not to stop you from not keeping it in priority.
Lordship.
You finish it. Once you have started it, you finish it. Make it under good condition. You apply this principle to other stretches also.
Lordship.
Correct?
This Lordship. Some survey has been done. It is in the list, and subject to now they have submitted the estimate. So this is the development, Lordship.
You are fortunate that we did not hear it in the first instance.
Lordship.
All right. Mr. D. Nath, senior government advocate, submits that by the next day, he would be in a position to inform this court regarding the
Approval of the estimate or
regarding the steps taken for repairing the stretch of road indicated in the petition, which is in a deplorable and unsafe condition. Let this matter come up for consideration. Just 6 weeks. After 6 weeks, in our.
Not.
40 August.
Deeply obliged.
Item 34. My pain start, my lord. Let it come tomorrow, my lord.
I have got some objections, my lord. What had happened
Yes,
in
but
this matter? One minute.
My senior.
After the
Yes,
affidavit
yes,
was filed, my lord, after the affidavit was filed, my learned friend had engaged the senior counsel, my lord. And after engaging the senior counsel on the last 3 occasions, my lord, my is the order sheet, the time taken on behalf of the senior. My lord, dispose it off, my lord. It's clear.
Mr. Mahanta,
Tomorrow, my lord.
have some spirit of camaraderie. Huh? He's not asking for a week's time. He's asking for
Day
tomorrow.
after tomorrow, my lord. Day after tomorrow.
I mean, let it, we appreciate your alacrity, but if you say like that, then we take a different, what happens if we don't take that view? Maybe a senior advocate would, or an advocate would project a case different. I mean, I'm not saying anything else.
I wouldn't have objected, my lord.
One day, for
Fourth
one day
occasion.
accommodation, we accommodate, don't we accommodate?
Yes.
The one day accommodation, what kind of brotherhood are you showing, no?
But for the fourth time, I'm just.
Let it be fifth time. Heavens are falling. Since when you're out of job?
6 years, my lord.
So one day it is going to make a difference. I don't think so.
Day after tomorrow.
Therefore, not tomorrow, day after tomorrow, tomorrow only. He has asked for tomorrow, why do you want day after tomorrow?
There's some other.
No, you want, look here, a prayer for adjournment for the day has been made by the learned council for the respondent number one. Respondent number one, Mr. P. Mohanta, learned advocate representing the appellant, admits that he will be in some difficulty tomorrow. Let this matter come up for consideration on day after tomorrow.
Deeply obliged.
This court is very, very particular that in such cases of, accommodation, the other side should not object unless heavens are falling. Otherwise, the court takes a view. Normally in Patna, if this was the view of an advocate, I used to say, well, the court wants time after 5 weeks.
Okay, so I'll keep that in mind.
If every time somebody is taking time and all that, we don't appreciate. But it's for the convenience of the bar. I mean, if we don't accommodate, would you be able to practice? No.
Exactly.
This is not the only court. You have to go in other courts also. You can't run your household by cases in one court. We accommodate, you also accommodate your colleagues. That's what, it's not only for you, it's for others also.
I was not objecting.
It has to be decided today. No.
I was not objecting. I was just pointing out for the fourth occasion.
Correct. Mr. Mahanta, day after tomorrow.
Day after tomorrow. Very grateful.
All right.
Item 45.
DM's order.
Your lordship.
Yes.
I am a service holder, government service holder. I have an account, salary account, which is blocked by the respondent authority illegally. Can impugn order illegally, suppressing the actual facts.
Just a minute. 1 minute. Give us a minute. Who appears for SBFC Bank?
It's a, as, myself, SBFC. It's an NBFC actually. It's not a bank actually. Non-banking financial corporation.
What is it? Non-banking?
Non-banking financial corporation. NBFC.
NBFC. And what is the current status of the bank account of this borrower?
We have enclosed in the affidavit. It is approximately 28 lakhs is due.
I'm asking for something else. What is the status? I'm not asking about the loan amount.
I'm sorry.
Is you have put a lien on his bank account?
Actually, before
Just a minute. We want to know from you. You are Mr. Mazumdar.
Yes, Mazumdar. Yes, sir.
Mr. Mazumdar, tell me one thing. Is there an agreement that you will put your lien on the bank account, savings account of the borrower? You have mortgaged his property.
Yes, Your Honor.
Correct.
Yes, Your Honor.
Then was that under an agreement that you put your lien because he would be receiving his salary, the other income? How have you blocked his income? Why should he not access his bank account?
Yes, Your Honor, it is completely right actually, and this was discussed sometimes earlier also in this. But what had happened is actually a sole arbitrator was appointed much before we had taken the physical possession or this one. So the sole arbitrator had given.
You have an account. You're not answering my question. Which?
I'm sorry.
Which bank are you keeping in your account?
SBI, State Bank of India.
State Bank. Have you made State Bank a party?
Yes.
Who appears for State Bank? How and on what request? How could you put your lien? Let's see the agreement.
Lordship, I appear on behalf of.
You can't be allowed to become a Shylock for something. And where is what moon is he? I mean, is he asking for something really ungivable? You give him the details of the loan. Where is the loan agreement?
The loan agreement is with
I mean, these officers of the bank, therefore, NBFC, we will be looking into your business now with this writ petition. How can you do that? Under which provision of law?
Your Honor, what
is the loan amount that you had disbursed?
We have disbursed approximately 21 lakhs or so. 21 lakhs.
And then why were notices being issued as if the loan amount was 30 lakhs?
Actually, this was done from a legal.
Is it not a fraud?
It's a wrong, and we have stated that it has been by a mistake.
Who are you appearing for, Ms. Himanshi Borua? Himanshi Borua? Whom are you appearing for?
Lordship, I appear on behalf of respondent number 4, Lordship.
Who is he?
Mr. H. Burago, Counsel for SBI.
SBI. What?
Yes, Lordship.
Do you have any instruction, or you'll ask your senior to appear here?
Lordship, he is out of station.
So out of station is all right. You have blocked his bank account on the request of a non-banking financial institution. Why?
Yes, Lord.
Where is that agreement? Where is that agreement? Why should he file a criminal case against the branch manager? When will your senior come?
Lordship, tomorrow.
We are fixing it next Monday. Ask him to be ready. And you also bring on record. What authority do you have to make a request for the SBI to put in lien? I mean, where have you put your lien? Let's see.
Lordship,
where is the lien? Under which agreement?
I will bring that agreement actually. But
I mean, put yourself. This is frustrating.
Lordship,
the loan may have gone bad. I appreciate. You can't possibly choke a person to death. This is what happens when people go to such fake institutions.
Lordship, this is not a fake
institution. So then you're behaving like one.
Lordship, I could pardon to say we are NBFC appointed by the RBI.
Whichever
you have already taken recourse under surface here or whatsoever under arbitration.
Yeah.
You have taken over position, tried to have a position over the land. Then where is the question of keeping his bank account?
My lords, you are right. The arbitrator stopping of the salary was much more.
Where is your affidavit? Reply affidavit.
Reply affidavit is there from,
Then mind you, with all statements made, the loan amount is 21 lakhs. and all.
21 lakhs here.
What amount has been paid up till now?
Lordship, maybe not yet paid because it is 21 lakhs has gone to 28 lakhs right now.
Agreed. The money has escalated because of his non-payment and
Non-payment.
addition of the interest.
Yes, sir.
Now you make a clear statement that this was the loan. Why were you issuing notices then in the beginning that the main loan amount is for 30 lakhs?
Lordship, only that part which was done by the council from the company from Mumbai, only the 30 lakhs was a mistake actually, that typing error was that's the only thing. But
That is
apart from and apart from here,
But then which property, the property which is pledged to you,
yes, Your Honor.
now would it cover the loan amount?
We had went for the sale, but
Would it cover the loan amount? Whether you went or you did not go, we are not concerned.
but as
What
per
is the valuation of that property?
valuation is approximately 30 to 35 lakhs.
So therefore your entire loan and interest is covered.
That's true. That's
Where
true.
was the reason for you to block his bank account?
Your Honor, what I am going to tell you is, Your Honor, please just for a
I mean,
minute.
it has
It
has raised us so much that I'm not able to even concentrate on the argument which you're raising.
That is true.
We will hear you. We will not pass any order without hearing you. But if the property which is placed, that can cover the expected price of the property will cover your entire loan and interest. Why should you choke him to death?
My loss, please just for 1 minute say
Yes.
what I'm going to say is that
Yes.
one sole arbitrator was given. Just for a sec. Sole arbitrator has passed one order that your salary will be blocked. That's what.
Your salary will be?
Salary will be blocked. That is the order which the sole arbitrator has given from the place of Mumbai. Now the thing is that letter was posted to the State Bank of India and State Bank of India had blocked it. We have not got the amount, but as of his case,
The State Bank of India's response.
after receiving the order from the sole arbitrator, the State Bank will block it.
Sole arbitrator says that you will block the salary.
Yes,
They can't do that.
that was the order. So
Where is that order?
maybe my friend has annexed over here.
And where has the
We,
lawyer disappeared?
it
Who's
isn't-
appearing online?
It is my on the affidavit in opposition, page number 27, the last page actually, where it says the sole arbitrator has blocked. Your Honor, please, my lords, please don't get angry. The thing is that after this was blocked, and after a gap of 4 or 5 months, we have taken the surfacey action of taking physical possession.
Sole arbitrator Delhi High Court.
Your Honor, on this basis, the salary was blocked.
Freezing the bank account number of council information, I have directed the authorized officer or control the produce the order control the bank qualified branch manager to bank of.
What business he had? What authority he had?
What is the present status of the property? They can
Present status, it with the physical person is with us only. It's with us.
Go for sale.
We had gone for sale, but but no bidders had turned our action.
So you will take away his bank account. Was that put, where is the agreement with you? And who is the terrifying? Now let us see the bank. State Bank. Ms. Borua. It's a very serious matter where a person's bank account has been sealed without any agreement, without the property. I mean, there is a lien put by this person. That statement may not be correct. Mr. Mazumdar says that NBFC has not put any lien. There was some order passed by an arbitrator, sole one-party arbitrator. I don't know what he has done. He says that he will cover. The amount of loan is covered under the pledged property, the valuation of which is more than the loan which he has taken. We don't interfere with the bank's process. But how could you, under what regulation have you blocked the access of the petitioner Your senior will have to say. Ask him to be here on Monday. Again, who is your senior?
Please, Guru.
We can't hear you.
Mr. H. Buragohai.
H. Bonbon.
Burabai.
Buragohai.
As in go. The. Take it. What is your name, Mister?
Yes, Government. Lordship, kindly, I want to submit one thing, just.
We'll say everything on Monday. Tell your name. Yes.
Mr. S. Burman. We have heard Mr. S. Burman, learned advocate for the petitioner, and Mr. I.S. Mazumdar for response number 2 and 3. Ms. Himanshi Barua has appeared online and has submitted that response number 3 is being represented by Mr. Borgohain.
H. Burman.
H. Borgohain, who is presently not
Respondent
available.
number 4, Lordship.
She therefore, respond number 4, no? Respond number 4.
Yes.
She therefore prays for some accommodation. The petitioners were husband and wife amongst themselves, had availed of a loan from SBFC Finance Limited, from a non-banking financial institution of rupees 21 lakhs. The petitioners had mortgaged a house as collateral surety. The loan went bad. The petitioners claimed that on one occasion, a demand notice was sent to him, sent to them, indicating that the loan amount was 30 lakhs. In any view of the matter, as it appears from the records, the loan has not been paid. The SBFC Finance Limited invoked the provisions under the SARFAESI Act 2002. A notice was issued to the petitioner under section 13(2) of the SARFAESI Act, demanding principal loan amount plus interest, bracket rupees 22 lakhs 49,201. The petitioners were also served with a possession notice of the mortgaged property. The property, as on date, is in the possession of the bank, of the loanee bank, possession of SBFC Bank, SBFC Banking, SBFC Finance Limited. The valuation of the property would, in all its probability, cover the loan as also the interest which is accrued. Notwithstanding this, the contention of the petitioner is that because of the so-called lien put over his state bank salary account, the state bank has blocked access of the petitioner to his bank account, thus choking him to starvation and death. The Land Council for the petitioner has submitted that regardless of the discrepancies which are evident in the loan documentation and the amount which is due against him, the blocking of the bank account, which is no part of the agreement, is absolutely arbitrary. The mortgage property is in the possession of the creditor bank. And in such a situation, it has been argued, the bank account, the salary account of the petitioner with the SBI could not have been blocked. The learned counsel for the SBI shall inform this court on the next day as to the authority under which the bank account of the petitioner has been made inaccessible for him. You also file your written response clearly. What is the loan amount? What do you want? And you proceed under surface.
Yes.
Don't touch his bank account. Let us hear from the State Bank and see what is.
Your Honor, apart from this one, actually, Your Honor, this sole arbitrator menace, apart from this one, is very strong over here. Any private finance, either in a Sorum Mandalam, Maruti or whatsoever, they will choose a sole arbitrator in the state of Kerala, West Bengal, Tamil Nadu. This is happening actually. I mean, my laws became very angry. It's a point that I could appreciate. But in reality, lots of people's vehicle are being seized on the basis of the sole arbitrator. We don't know where from that letter comes. Lots of bank accounts have been blocked.
We are keeping it after 2 weeks. Okay. You inform your lawyer, you inform your senior, Ms. Barua.
Yes, Lordship.
Re-notify on so and so date. After 20.
8-6, no? 10-6.
Obliged.
Item 36 for hearing.
Yes.
Mr. Ganguly is engaged in a part admitted in court number 13 lordships.
Mr. Ganguly is appearing for whom?
For the bank lordships, as per number 1, 2, and 3. Was a fixed metro rate 2 lordships is engaged there. So I paid it the matter be taken by any another entity.
On account of absence of Mr. Swanson, who has to address this court on behalf of the respondent bank. The matter is adjourned to. After 1 week.
11th June.
Oh, and you're black.